Hi and welcome to the show. Most people don't know what to do or expect when faced with a legal dispute, be that in matrimonial, labor law, debt counseling, property law, or more. We aim to give our viewers a broader understanding of the law in South Africa to make sure that the vulnerable are not taken advantage of. In this show, we address your questions that are sent to us via our email and our WhatsApp platform. So don't forget to send in your questions to the email and the WhatsApp number that will be provided at the end of the show. I'm your host, Fazloodien Abrahams. You're watching the Fazlaw Show on Cape Town TV. According to an article in Biz News, which contained an open letter to our President Cyril Ramaphosa, written by Gerard Papenfuss, the issue of mandatory vaccinations, the most controversial topic globally, has the potential of tearing our society apart. Moreover, the letter refers to a statement made at the 110th anniversary of the ANC, in which our president urged its citizens to ensure they are vaccinated as soon as possible to enable the economy to return to full operation. However, at the time of recording this episode, 3 months after this statement by our president, only 50%, that is plus minus 32 million people, of our population were or has been vaccinated. It appears from the above-mentioned article and the open letter that to be or not to be vaccinated surely has a negative effect on us trying to live a good life, or does it? However, there is hope, and newly amended laws appears to be a solution, or does it? With me today is our guest expert, Faizel Rodriques, an admitted advocate who commenced work as a head of Dispute Resolution Directorate in the Department of Health, where he acquired extensive experience in managing disputes and hearings. Faizel is a labor law specialist with expertise in managing sexual harassment cases, all labor disputes, and forensic investigations. Faizel, or Advocate Faizel Rodriques, rather, let me address you properly.
You can call me Faizel Rodriques, doesn't matter.
But you earned the title.
Yeah.
Welcome, and thank you for being on the show.
My
Faizel,
pleasure.
as you know the topic, it's mandatory vaccinations, and we would like to definitely take you through a couple of questions. But I just want to lay the foundation quickly. So there's been more than 117 disputes lodged at the CCMA at the time of recording this particular episode on that topic. And the question is, the way the government rolled out the mandatory vaccination policy, do you think they had the cart before the horse? Do you believe that they should have done it a bit more? And I think perhaps information, awareness. What's your view on that?
Look, we need to realize that the pandemic came upon us suddenly. And when it came upon us, we immediately went into a lockdown. Because it was a defensive mechanism of the government to secure the livelihood of the community and public at large. So on that basis, thinking back, many of us would have different viewpoints as what should have happened. My opinion, and that's my opinion, I think that the government should have acted sooner to set out a mandatory vaccination framework, because it could have, I'm not saying would have, it could have saved lives in setting out that framework. And we also know that 40% to 50% of people becoming affected were affected from the workplace. So yes, they could have done it earlier. Okay. The method of how they could have done it was very difficult, because remember, we were still in a lockdown phase. So my opinion, I think the government did what they could.
Thank you, Advocate. Another question that I want to perhaps look at is, there's a recent gold rush case.
Yes.
And in that case, the employer convened an inquiry regarding the incapacity. The employee refused to be vaccinated, and they then subsequently dismissed her. And at the CCMA, it was held to be fair, that dismissal. What are the other examples of a dismissal and the reasons that one could find in the workplace when it comes to, incapacity is one, So what is incapacity, and what's the other type of dismissals you could find?
Okay, incapacity deal with a situation where there could be a no-fault environment, meaning where the person is, due to illness or injury, cannot continue performing what is required from him by the employer. The employer can take him through a process and determine whether he can accommodate that employee. If not, it can dismiss that employee. That's the one incapacity. The other incapacity deals with performance, poor performance. If an employee doesn't meet the standard of the employer, for whatever reason, that employer's got a right to terminate that contract, but there's a process that needs to be followed. Now, incapacity has got two legs, the one for illness and the one for performance. There's different processes used in determining whether the dismissal will be fair. In this case, the gold rush case, the court was faced with, what are we dealing? Are we dealing with a misconduct employee, or are we dealing with an incapacitated employee? And if we're dealing with an incapacitated employee, what type of incapacity are we dealing with here? And the court came to the conclusion that we're dealing with an incapacity that falls within the ill health fraternity or environment. Hence, if you take a look at the framework determines the factors you would determine for incapacity ill health.
I want to get to that later with regards to that framework. It's definitely part of the discussion. Just quickly on the statement, our individual rights are limited.
Yeah.
What does that mean regarding, with regards to the mandatory vaccination policy?
Okay, if you look at the mandatory vaccination policy, there are certain requirements that the employer need to meet. First and foremost, he must look at the risk assessment. Looking at the work environment, seeing how he can assess the situation, whether his employees come into close contact with members of the community or fellow employees. If that is the assessment done, he then needs to develop a vaccination plan. And part of those plans, he will also have to convey that information to the employee. There's about 11 factors that they need to consider. Now, from those factors, once he's conveyed that information to the employee, he must make them available or register them to be vaccinated, and he must give them time off for them to be allowed to be vaccinated. He also, in terms of his plan and his risk assessment, identifies certain employees that where mandatory vaccination is important or compulsory. Now, in many cases, you will look at people working in sales that come across members of the public on a continuous daily basis. Those would be people identified as mandatory vaccinated employees. Also, employees working in the open plan government. You have a lot of open plan offices where staff sits close together in situations such as that. They might require that employee be vaccinated.
Let us continue that discussion at a later stage. We have come to the end of the first segment. We'll definitely continue after the ad break. Yes, ladies and gentlemen, the viewers, we've come to that point where we need to switch over. Please follow us after the ad break and keep on watching. Welcome back to the show. In the first segment, we looked at the statistics of vaccinations in South Africa. An article from the Biz News, and we got to know our guest legal expert, Advocate Faizel Rodriques. Then towards the end of the first segment, we had a short discussion on usual disputes and the legal ramifications when an employee or an employer don't abide by the law. I'm your host, Fazloodien Abrahams, and you're watching the Fazlaw Show. Welcome back, Advocate Rodriques.
You're welcome.
We definitely need to go to our next questions, and I just want us to touch basically on how long does a dispute take at the CCMA?
Basically, it depends. If you dismissed, you got 30 days to refer a dispute to the CCMA. You actually do a referral for conciliation, and that should take place within 30 days' time.
So this is someone who has now been
dismissed.
Dismissed because of incapacity. They refused to be vaccinated.
Correct.
Right.
So then he's got 30 days to refer a dispute. Right. Now, after that 30 days, there's a 30-day period where it should be set down for conciliation, where the employer and employee gets together. You have an arbitrator sitting as the conciliator, and he try and resolve the dispute.
So from the date of lodging your complaint or dispute,
It's a
right
30
up to
days.
the end, how long can it take? About
About
6 months, 3 months?
It should take about minimum 2 months.
Okay.
But you always look at about 3 months, 3 to 3.5, 4 months.
So given the time frame, if you as an employee has a capacity to negotiate or discuss the matter with your employer, do you think that it would be better to appoint an attorney or a mediator to then, after the dismissal, try and mediate the matter? Or is that conciliation process part of the mediation
The
process?
conciliation process is a mediation process where the conciliator sits and he tries to resolve the two issues where that person was concerned. But unfortunately, the CCMA rules, which applies to your bargaining councils as well, does not allow legal representatives to sit in the conciliation. They allow union representatives or fellow employees to act on behalf of that employee. It's a very informal process. So the employee tells what his story is, what he wants the outcome to be, and the employer will respond. And if they don't meet a settlement, the conciliator then gives a non-resolution certificate, which is exactly the same as a mediation process.
Sure. With regards to the appropriate circumstances, so I've got a list of questions that are posed by the viewers, and one of the questions was, with regards to appropriate circumstances required for mandatory vaccinations to be enforced, what are those appropriate circumstances according to the law?
According to the mandate,
That's the current law, right?
Yes, framework.
Yeah.
And that's incorporated into your Occupational Health and Safety Act. Now, it says that, as I've indicated in the first segment, there must be an assessment by the employer. He must draft a development plan. He identifies mandatory vaccinated employees.
Okay.
You now have a discussion with them, tell them, look, there's certain grounds where you need not be vaccinated, and if that employer refuses to be vaccinated, he's got a right to inquiry. Why is he refusing? He can send it to counseling and get some other guidance. And there's only 2 grounds where the employer basically can say why he doesn't want to be vaccinated, based on medical grounds and based on his constitutional rights. Now, those are 2 grounds that the employer must take into consideration. And when he does take it into consideration, he's got a right to ask that employee to go back for a second medical opinion. And if it's reasonable, the second medical opinion, he then needs to consider how does he accommodate that employee in the workplace. Can he put her in an office alone without having to come into contact with any members of the community or fellow employees? Or is it possible that that employee can work from home?
Okay.
So those are things that you need to look at. The issue on constitutional grounds, religious rights.
We'll get to that.
Yeah.
We'll get to that. Let me follow up with another question posed by the viewers with regards to representations.
Yeah.
So the staff member has now been informed that there is a disciplinary hearing and they are allowed to make representations regarding that disciplinary, or is it after the dismissal that they are allowed to make representations?
You see, at the end of the day, if you take a look at his being dismissed for incapacity, so there should be a process. There should be an incapacity inquiry where the employer states his case to a chairperson, and that employee states his defense why he should not be considered.
Well, let me rather pose a question this way. We're now looking at the reasons for refusal, and those reasons are considered as representations.
The reasons for
Reps.
refusals, okay.
To be vaccinated. The question is, what would be considered as acceptable and valid reps to not be vaccinated?
Any reason, even if it's appeared to be unreasonable, but investigation
Will conclude
that maybe it's reasonable for this person from this person's point of view, and the employee accepts it.
So you would say that a valid reason would be maybe a religious,
Religious
or,
belief, yeah.
medical, for
Yeah.
example.
Yeah.
Okay, all right. Then with regards to reps, I've done that one. What happens if the reps are not accepted?
Well, if a reps is not accepted, as I've just indicated earlier, the employer is now faced with a decision either to accommodate, if he can accommodate that employee. If he cannot accommodate that employee, he then terminates the employee's employment contract based on incapacity. Now, because that decision of the GORAS is so recent, we also need to look at how do you practically do it. And there's got to be an inquiry.
And that comes to procedure.
Yeah.
So there's two legs to the dismissal. Is one is the
Substance.
procedural and the substance,
Correct.
the substantial. Procedure. What is the procedure that needs to be followed?
Basically, the procedure need to be followed is for the employer to show that he's met the mandatory vaccination framework. So in doing that, he then sets up an inquiry with a chairperson, and he then follows that process and say, look, this is a risk assessment that we've done. This is the vaccination plan that we've done. We've identified this person as, for example, as a mandatory vaccinated employee. She's given us her reasons on the constitutional grounds. We've looked at whether it's reasonable or not. Even though it was reasonable, hypothetically speaking, for example, we then offered her accommodation outside of her current workplace. She then refused to take that, and we then decided to terminate the services. She then has got a right to defend herself, even to call witnesses if need be, to show that the employer's conduct wasn't reasonable and fair.
Sure.
So that's your process that you need to follow. If that process is not followed, then the dismissal is procedurally unfair.
Okay. Human rights.
Yeah.
What human rights, or which human rights can a worker enforce or claim in order to prevent being vaccinated?
Freedom of choice. And there's a right, your right to religious beliefs. And there's a right of your integrity not to be injured. So those are rights that you can look at. And as I've earlier indicated, it might appear or sound unreasonable. But if that employer give a justified reason, the employer must consider whether it's reasonable or not.
Okay. That, Faizel, that brings us to the end of the second segment. I want to just follow up with some other questions, but there's a very, very important discussion that I want to have after in our next segment. Thank you, viewers. That is the end of the second segment. Keep on watching. We'll be back with more answers to your questions. Welcome back to the show. In the second segment, we started with a recap on the first segment. We discussed the efficacy of the current laws pertaining to labor relations and if those laws needed to change. Towards the end of the second segment, we had a question and answer session with our guest legal expert, Advocate Faizel Rodriques. I'm your host, Fazloodien Abrahams, and you're watching the Fazlaw Show on Cape Town TV. Welcome back, Advocate Rodriques. I want to continue with the questions posed by the viewers. And one of those is, can I be fired without a proper hearing being held at work?
The answer is clearly no, because that is why the Labor Relations Act makes distinction of 3 different types of dismissals. The one is for misconduct, and it's got its process where they call you into a disciplinary hearing. The incapacity process, as I've indicated to you, has 2 legs, but that's your second type of dismissal, where they hold an inquiry, take you by the hand, and see where we can accommodate you in short. The third one is operational, where the employer says, look, there's a change in our structure, especially when it was with the pandemic and after the lockdown. They couldn't afford to maintain the amount of staff that they have within their workplace. They had to downscale. And with that downscale, Section 189 of the Labor Relations Act says how you need to deal with dismissing that type of employee. So 3 different types of dismissals is based on 3 different type of procedures followed. But a procedure must be followed.
Fine. So now it's found that the employer has failed to follow procedures. And at the CCMA, the dismissal is now considered as unfair, and a compensation needs to be made. How do they calculate that compensation?
Well, there's different factors that the arbitrator will look at. But remember the Labour Relations Act, I think it's in 194 or somewhere around there, says then when you do look at compensation, it must be equivalent to what that person earned on a monthly basis.
Okay.
So if he says 5 months salary,
Yeah.
the total will be equivalent to 5 months of what he would have earned had he worked.
So let's say unfair dismissal, we're looking at a maximum of 12 months or 24 months?
For the act unfair dismissal, it's 12 months. Automatically unfair dismissal is 24 months.
Okay.
Now there's a difference.
Now with regards to the other options, when you're talking about unfairly dismissed, right?
Yeah.
What other options, let's just see. Yeah. Can we looking at compensation? We're looking at what else?
A reinstatement, reemployment. Okay. Now there's a difference between the two. Reinstatement is where the arbitrator reinstates you because your dismissal was substantively and procedurally unfair. So he reinstates you, and it means you get all your benefits back as if you were never dismissed. Mm-hmm. So that dismissal falls away completely, and the arbitrator then reinstates you retrospectively. But the arbitrator can also say, even though it's retrospectively dealing with your benefits, I'm only awarding you 5 months' salary, say if he was now off for 10 months. And he would give a reason for that. The second type is reemployment, where you come back as a new employee on new benefits. So then, whatever future or history you had with that employer technically falls away because you now start as a new employee.
What is a vaccination plan?
Basically, the vaccination plan is a plan that the employer sets up and becomes a workplace rule or policy. And that plan, he will indicate who will be a mandatory vaccinated employee. And he will also indicate if he doesn't want to be vaccinated, there can be how he's going to accommodate that employee. He will also indicate how many employees he's got in his workplace and who is mandatory. So you give the stats of employees and how he will deal with terminating the employment services of an employee who refuses to vaccinate. So that's all part of his plan.
So now one of the employees has indicated that based on medical grounds, they refuse to be vaccinated. What would be the steps that the employer has to follow?
Yeah, basically, the employer will approach the employee and say, what medical grounds are you referring to? He then will ask him to seek a counselor for further guidance. Secondly, he can then send the employer to a doctor he has appointed for a second opinion. And obviously, he must tell the employee the consequences if the second opinion doesn't correspond to what she is saying, why on medical grounds she refuses to vaccinate. However, if she can prove that a vaccination will be detrimental to health, then that would be a reasonable excuse not to be vaccinated.
What is a collective agreement and how does the collective agreement affect a mandatory vaccination plan?
Okay, a collective agreement is agreement entered into between the employer and the employee's representatives. In those instances would be the union. And they will enter into such a collective agreement either with the CCMA coordinating it or the bargaining council coordinating a collective agreement. They agree to the terms, and that then supersedes any other law other than the Constitution. That's the effect the collective agreement has. So with a vaccination plan, it's a policy by the employer. The collective agreement will supersede that plan.
Thank you, Faizel. Advocate Faizel Rodriques, we've come to the end of the question and answer session, and I thank you for being on the show.
You're welcome.
And we're definitely looking forward to seeing you back on the show at our follow-up episodes. Ladies and gentlemen, that is the end of the show for today. But before you go, I want to make sure that you get your questions to our department. You can email it to info@fazlaw.co.za, or you can WhatsApp it to 082 495 8989. Please, we need your questions so that we can have content for our episode. You are the most important person in the show. Thank you for watching The Fazlaw Show.